Any update here? Go ahead.
All right. Well, thank you for sticking around. The next item is an update on zoning ordinance update, and hopefully we're kind of coming to the end of the process. At the last Planning and Zoning Commission, we did have a public hearing on the zoning ordinance, and Farm Bureau was the sole presence and comment from the public at that meeting regarding the recommended changes. What we'll do is Colin will come up and kind of summarize some of the comments that were made from both staff, because after thinking about a few things, we have some additional comments we'd like to make. Then Colin can summarize some of the things from Farm Bureau, and Mark is here as well. So he feels the need to provide some clarity, and more than happy, I'd love to hear it. So after Colin does that, we have Kirk Bishop, the consultant, present today. We'll probably go through again some of the more major substantive changes that will be occurring in the ordinance, with the desire of getting some feedback from you on those topics, further direction as to how you want them addressed, how you might want any public comment or staff comments addressed for the next iteration of the draft. And so with that, we then have another meeting after today to come back to the committee with those final changes. Hopefully we think we can do the final changes. And then go through the ordinance in its entirety with the changes and make clear that everybody understands what the recommended changes are. And then at that point, we would have it transmitted to the full board for consideration with the target of being in December. So with that, if you have any questions for me, I'll be happy to answer them. But with that, I'll just turn it over to Colin, let him talk about the public hearing, and then we'll let Kirk Bishop come up and go through some of the major areas we'd like to discuss today.
Okay.
12:30, so good afternoon. At the public hearing, we did receive a few comments, one from the Soil and Water Conservation District, that we had some archaic language in our current zoning ordinance, and they would like it here replaced, and we can easily do that. Thank you. For accessory buildings, the Planning and Zoning Commission was opposed to the reduction in the square footage, as you can see on the screen here, because they believe the caseload is already substantially part of variances for accessory building area. So if the area is reduced, they're expecting to see an increase in their caseload. For accessory dwelling units, we received a letter of support from a family out in Frankfurt Township. Commercial vehicle parking, we are anticipating we're suggesting increasing the restriction. It's currently at 8,000 pounds for a V as in boy plate. That's what our current proposal is, and it's consistent with the current language the zoning ordinance has, but we're suggesting an increase to 12,000 pounds and a D plate for commercial truck storage. For solar farms, much of what Mark has mentioned earlier, he said it at the public hearing, particularly with regard to this scrap value, the IDing of the drain tiles, and the increasing, or the mandatory increasing of screening for the solar farms. And we also had to make some changes within the proposed text in order to get it consistent with state statute and consistent within itself. We changed a lot of the applicant shall to owner-operator in order to make it more consistent throughout the text. So those were the comments that at the PZC.
Okay, thank you. Any questions by committee? Okay. Key issues that we would appreciate some maybe additional policy direction
from the committee. We'll begin with the subject of the accessory building area restriction. We had heard at the beginning of our process some concerns that the existing limitations on the amount of accessory building area on a residential lot may be, in some people's minds, a bit excessive in terms of what would be considered customary in a residential setting. You see there on the chart the existing limits, 1,800 in R3 and 1,500 square feet in R4 to R6. That would be today's ordinance, what's on the book today. In response to the concerns that we had heard at the outset of the process, we had suggested reducing those by in the approximately 20%, so down from 1,800 to 1,500 in the R3 district and down from 1,500 to 1,200 in the other R districts, the higher intensity R districts. What Colin had suggested, Colin had summarized the feedback that we got at the Planning and Zoning Commission meeting last week. The reaction was, gosh guys, I would have gone the other way with those limits because of the number of variance requests that we hear for folks who want to exceed even the 1,800 and 1,500 foot limits that we have today. So it was on that basis that we thought, well, we need some additional policy direction. We need to inform you of the objection raised by the Planning and Zoning Commission and see if you have additional thoughts on this issue of what is the appropriate limitation for the amount of accessory building floor area or under roof area on a lot. I'll remind you there is an additional limitation, the 20-foot height limit. That's not a new standard despite the fact it's red on that chart. That's the existing limit. What's important to point out about the existing limit, however, is that one of the kind of tweak amendments, technical amendments in this round of amendments is the way that height is measured. Under today's ordinance, height on a pitched roof building is measured to the mean between the top of the ridge and the underside of the eave, so you get to about the midpoint of the roof. The proposed amendment would always, in the case of a pitched roof, measure to the highest point of a roof. So that 20-foot limitation is, in full disclosure, a bit of a reduction from today's limit, and maybe that in and of itself could help to alleviate some of the concerns that folks have about the scale and size of accessory buildings on a lot.
Okay, I'm not in favor of revising what we did put up there, 15 and 1,200. If they request a variance, do they notify the adjacent property owners? And they come to, they can come and object to a variance, David?
You can get an administrative adjustment up to 10%. There is a process for that, but a full variance requires a public hearing, and yes, it does require adjacent property notification, publication.
So then the neighbors would be able to come in and talk if they didn't want this large building next to them. So any other comments by committee?
I would ask David, though, is the majority of those variances administrative variances that don't exceed the 10%?
Most of them are over 10%.
Most of them are
Most
over
are 10%.
10%. Okay.
Any questions by committee? Okay, we'll let it stand the way we had it revised.
As drafted, bring that forward in the package of amendments. Yes,
Yeah.
thank you, Mr. Chairman. The next issue is the subject of accessory dwelling units. You may remember from our previous discussion that we're proposing a change to the ordinance that would authorize accessory dwelling units, separate accessory dwelling units on the same lot with a principal dwelling unit. That could take the form of creating a separate walled-in area within the roof of the principal dwelling in the basement or in addition to the house, or converting perhaps unneeded garage space or something like that. or it could take the form of a detached unit in the backyard, a backyard cottage or something like that. The draft as proposed would allow the interior conversions, the interior accessory dwelling units as a special use really across the board in all the districts that have a residential emphasis. The detached ADUs would become a special use permitted in the R1 district and continue as a special use through all of the R districts. There's a couple of things I should point out as a companion to that. One is that there are standards that are associated with these units regarding the size. It has to be less than half the size of the principal dwelling to qualify as an accessory or subordinate.
Also a maximum of 650 square feet.
Or 650 square feet, or 49% of the size of the principal dwelling unit, whichever you get first would be the limit. The number of accessory units on the property could never exceed one additional unit. The number of occupants overall would be subject to the same limits as if you didn't have an accessory dwelling unit on the property. For example, the definition of household in the ordinance today basically says any number of people who are related by blood, marriage, adoption, or traditional familial status constitute a household, or up to a certain number of unrelated persons. So the way that the ADU provision would work is that you would look at both the ADU and principal unit together to see if they meet the standard of a single household on that property. So that's intended to prevent there being multitudes of people living on a property that heretofore didn't have that number, and there are some other design standards associated with it.
Comment?
So I have a question then. So the attached is special use for all of our zonings. Detached is special use for R1 through R5. A1, E1, E2, and R6, you have a dash. What does that mean then?
It means as drafted, it'd be prohibited in those districts. So if you felt that they should also be a special use in those districts, we certainly are.
Yeah, I mean, they're larger pieces of property than the R1 through R5, so I don't understand why we would allow them the special use through there, but not allow them on a larger piece of property as right or special use. It doesn't make any sense to me.
It's a legitimate question. We were scratching our heads before the meeting
I don't
about
know
how
who
we
came
got
up
to
with
that
that, but-
recommendation.
To me, that makes absolutely no sense.
It's counterintuitive. I'll bring to that.
So you're looking for that?
I either that or even an ag, put it as a right. I guess that'd be something we'd have to talk about. But I mean, your ag parcel's minimum of what, 10 acres about for an A1?
It's supposed to be 10 acres.
It's supposed to be 10 acres.
It's supposed to be 10 acres. So you're talking about 10 acres if you have an accessory building that you're not currently using. You can get a special use permit in the other ones. It doesn't make sense why you couldn't do it in an ag property. It makes absolutely no sense.
I thought,
Keep in mind, there's a lot of A1 parcels out there that are not 10 acres.
correct.
For whatever reason. So I think if you were gonna do that, you'd say A1 and 10 acres or more. Because there's A1 out there.
There's a lot. I know there's a lot that allows.
There's a lot out there that, they split things up, there's an acre left, or 3/4 of an acre left. So I would be careful with saying.
What does the special use do?
Keep in mind, we're talking about just the accessory building.
Right?
For special use.
Correct.
Detached versus attached.
Correct.
What came up in that meeting, I believe, was that the detached was going to be a right, it was going to be allowed in ag.
Well, it's
So I
not.
don't know why the dash would be there. I think that as for a special use, they were going to have to come before us, but I believe in A1, A2, and E1, that was by right.
Okay, so it's more of a typo on our part.
You're right, I remember that.
But like Jim mentioned, you want to say
Well,
for size.
I mean, you could do it for every parcel. I mean, you could say A1 of 10 acres or more, E1 of 5 acres or more, E2 of 2.5 acres or more. They attach some acreage to that.
I kind of like that, and then R6, I mean, that's got a dash as well, so.
R6 is apartments.
No, I'm just saying, they all have that same dash, so when you're looking at that, it seems to be about the same. Obviously, it is not, but, and then yours doesn't match because R5 up there has an S and you don't have an S down there. So I think that, to me, it makes sense, Jim, that we say that it should be the A1 with the, what an A1 really is 10 acres or more. Otherwise, special use permit requested for that. Is that fine, Jim?
Yeah, I think that's the way to do it.
What is A2? Is that,
A2's.
There is no A2, it's E1 and E2, not A3.
Well, A2 still exists, it's
A2
just,
exists.
A2 still exists on,
Oh, I'm reading the screen up there.
Right, they don't match this.
Okay.
Right. Well, Dave got his hand. We can't see it.
Sorry.
All right.
David?
If the desire of the committee is to require that all parcels meet the minimum lot area of the individual zoning districts, that can be a single item within that section where we make a statement as such.
Well, what I was hearing, David, was that it would be permitted as a right if it's in those districts and meets the minimum lot size standard. The open
Yes.
question would be then, is a special use a possibility for those zoned A1, A2, E1 parcels that don't meet the
If they
minimum?
don't meet the area
Yeah.
requirements,
Yeah.
then they would have to go through a special use
Yeah,
process.
okay. Okay. That's terrific direction. I want to point out one other thing, just so we're all on the same page. There is a provision in today's ordinance that allows something called related living, which is essentially an internal accessory dwelling unit occupied by people who are related
Right.
or family members. It could be grandma, it could be the son or daughter who moves back from college. A separate kitchen is created, bathroom within the unit. So it was a kind of related ADU. Our proposal would eliminate the related living provision and instead allow that through the ADU process. The problem with the related, one of the issues with regard to the ADU, the related living, is that long-term enforcement of that is difficult, and it would just be cleaner if everyone was on record initially that ADU can be occupied by a family member or not. Because once it's created, it's probably going to be occupied long-term and rented out over time. So just wanted to get that on the record.
Okay.
Did I forget anything, David or Colin?
No, we just want to make clear that the related living would no longer be within the ordinance. And Kirk had identified that one of the reasons why is that once the related living is established within the unit, there's no process or guarantee that it remains for the intended use and does not become an apartment afterwards.
Okay.
And this way it gives the board the discretion and the individual attention to every situation as to authorize it.
One final point. ECHO doesn't go away. Related living will go away. ECHO units will remain a separate option, subject to separate standards under this proposal.
Yeah, because it's a different type of.
Yeah, I just wanted to make that perfectly clear.
Can I ask a question?
Sure.
So then, my question is this, I don't know who has the answer, but, so the accessory dwelling unit that currently is taxed at whatever, say I have my father-in-law used to have pigs, an old pig barn, if he wanted to convert that into an accessory dwelling unit. It's well, it's nothing wrong, it's got a concrete floor. He's got to come out and see it. Mark, maybe you want to live there when you retire, so. But anyway, I'm just saying, so my question is, it currently is taxed at whatever rate it is. So then, if you took that building, converted into accessory dwelling unit, then the tax for that would change? Or property tax, or, I mean, how does that happen?
I can't speak to the assessments.
Okay. I was just curious. I mean, it would be an improvement, obviously, to the building, so.
Yeah, theoretically.
We're like the related living is not. Okay, I mean, thank you.
So I was here for your previous discussion of solar farms, I'm sorry. I don't know if it's your desire as a group to kind of work through the ordinance issues today, get some additional guidance. We have many of the same questions that arose today with regard to screening, when the visual screening or landscape buffer would be provided. The proposed ordinance would authorize you to impose that as a condition of approval of the special use permit. It doesn't necessarily require it as an objective standard in all cases. So we appreciate any feedback you have on that. We've also heard that drain tiles are an issue that should be considered up front through a drain tile survey or some kind of analysis of drain tiles because of the amount of pilings that they'll be putting in to mount these ground-mounted equipments. That's not currently a part of the ordinance. Financial guarantees. We've kind of gone back and forth on that in the draft. The current draft does require a financial guarantee, but that financial guarantee doesn't kick in until the facility's been in operation for 10 years. Or the other way around? Yep. Okay. So the current draft requires the financial guarantee at the time of permit issuance.
Correct.
One of the proposals that we've heard as part of our back and forth both with the industry and stakeholders is that the more reasonable approach might be to kick it in at a later date, say 10 years into the project.
So I'm confused, so if you don't do it till later, financial guarantee meaning what? Security bond on it?
Yeah, that would be the typical form, some kind of bond to ensure that if they walked away, that it could be properly decommissioned and put back to
It seems like, to me, it seems like it should happen right away, because what if they walked in 5 years, then what do you do? You can't see that, it's like,
Yeah, sorry.
Okay.
So I worked with Colin and we weighed out all the different options of what different counties are doing. LaSalle County, which is where that very large 20 megawatt, 144 wind machine farm sits in the Streeter area, they required an escrow account during construction. That really is the riskiest part of solar farm development, because if they walk at that point, they have to find someone to finish developing the project. Now, they required no decommissioning surety that be held with the county after construction is complete. If this company, any company, goes out of business after the system is already electrified, 9 times out of 10, according to the industry, they will sell that system to another owner-operator before they'll just walk and let it degrade. It's a very expensive asset to leave behind, especially if you're hurting financially. So really, I think one of the options Colin has on his board there is to hold a surety during construction, and then determine what happens after that.
That sounds reasonable.
Do you have any comment on that?
Mark, do you have any comment on that? No?
It's okay.
So that would be this where we do not collect any decommissioning surety bonds
Okay.
at all. It
But
would
during
just be
construction, we were there.
Correct. Consensus with the committee to go with the least restrictive option?
Yeah.
Yeah.
Mark, I really want to hear from you on that. He's got 3 options here before us, so I really want to hear from you as to what you think, Mr. Ag.
So the current language has us retrieving a financial surety bond at construction with all the inflationary escalators, the value, and updated every 3 years. What the midpoint would be, instead of at construction, at a 10-year mark. instead of immediately. So there isn't that initial funding that's needed. But with everything else, a more less restrictive update every 5 to 10 years, or do what LaSalle County did, which is none of the above. It only required a construction bond, after the initial construction, instead of decommissioning. Decommissioning would be within the contract of the property owner.
I would lean towards the current language with your decommission.
Yeah, problem. Decommissioning of it.
I don't like that scrap value. I think that's going to take it out, right?
It does not, none of them speak to including scrap value. So if you do, you could also do, oh, I'm sorry.
Yes, it does.
Oh, I apologize. You could also do the escrow account during a construction bond, and then you could have the decommissioning surety that follows. But again, the riskiest part is bringing that project to fruition. All of the cases where we've heard, such as like Sun Edison, huge developer that went out of business, and a lot of the projects were half developed. Therefore, having a surety for decommissioning did them no good there. So having something to make sure the project is actually finished.
At this point, though, how long have solar farms been around?
So in Illinois, the solar farm in Streeter has been around for 5 years.
Okay, so we have not been around that long. This is a newer type of energy source.
Sure.
We don't know what the future is going to bring. There may be a better energy source that somebody develops in kindergarten or right now is going to develop when they're 22. I don't know. In which case, we don't want to really be stuck with it. Well, just because it's feasible now for another solar energy company to come in and buy it, it may not be feasible when that kid whose kindergarten is 22 years old. We don't want to be stuck with solar farms sitting around with all kinds of contraptions on it. Gymnastics.
The only concern I have, we're looking at, for the state of Illinois, probably between 10 and 12 different solar companies. I'm not sure all these solar companies are going to be valid after they get done with their money in regards to the cost share dollars at the federal level. And my concern would be is that some of those are going to go, we have seen what some of the other renewable energy has done in some of the other areas. Once the money was gone, they wound up filing bankruptcy. That's a concern I would have with the number of them. If I was only dealing with one, I would probably say less restrictive. But we're dealing, like you said, you've got another 4 or 5 more, and you're probably going to have more. I don't want to see 7 or 8 solar companies in Will County all go under, and then we don't have any decommission to clean them up.
Sure. So you could do a combination of a construction bond and a decommissioning surety. I will state that industry feedback from developers that I have spoken to about the options on the first most restrictive option, just for the knowledge of the committee, there is no interest in developing solar in Will County because of tying up that amount of capital from day one is too intensive. That's just for your knowledge.
Jim, did you have a comment?
Well, I think they have a couple of comments. I have some of the same concerns. It's like when they built the railroads. Initially the money wasn't operating the railroads. The money's in building the railroads. For the profit. The same thing here. I don't know if there's real profitability in the operations of these solar fields, at least of this size. Their money is in the incentives or in the development of the. So I do think that. So they're not going to have a problem with the upfront cost. They may have a problem with the decommissioning. But shouldn't we have something if they just abandon these sites?
Sure.
That somehow, at least, we have the ability to take them over. They forfeit the, so what do we do if they say we're not decommissioning it, they just abandon it? What do we do? How do we make a determination whether they've abandoned it?
Well, it's a year if it's not functioning.
Well, that mean that one day out of 365, they crank it up and say, yeah, we're operational? I mean, so these would be my concerns about, I think this is likely to be abandoned, is they're gonna say they've been decommissioned. So there has to be some kind of protection there. And then I don't know what's our liability. And then does it diverse back to the farm or the landowner? I mean, does the landowner then have some responsibility?
Absolutely.
Because they've been in the lease. So, I mean, what is that? So, I mean,
Just like anything, any other
It'll be like any other, well, that's true, but on every other development we have bond. You abandon a housing development, and we have to go in and finish the infrastructure or the public improvements. We foreclose on your bond, and we can do it. What can you do here? I mean, what's in a lease between the landowner and the developer? I mean, I think it's a little more complex than you think, so.
In the submittal for a solar farm application, we require a redacted copy of the lease, which most of them speak to decommissioning. I also want to point out that we did talk about in conversation with staff that we don't require decommissioning bonds for cell towers. That is a similar situation. It's a lease between the landowner and the owner of the cell tower.
That's covered by state statute, though.
So covered by state statute, wind is as well, and so in the future, it's very likely that the state will have something for solar.
So let me ask you,
In the meantime,
should it fall back on the property owner, saying within your lease, you're responsible for this? So they know, I mean, they're the landowners.
same conversation that we had as well.
So I think you have to look at the land.
I'd say it has to be,
Not the operator.
And in requiring a lease for submission for the permit, we would also be able to validate that there was a decommissioning clause in the lease.
Brian?
Thank you, Chairman. Well, another point I want to make is that this is, a lot of our subdivisions, as we're going through development, maybe we're talking about a few years to maybe 5 to 10 years. Now you're talking about 30 to 40 years. And the county is not, there's no application fee that we're taking in to manage this bond, which, if you're asking the county to manage a project and it's not receiving any compensation at all for that time period. When you're doing things like that, there are annual checks that you have to do and you're going back and forth with financial institutions and things of that nature. So I just want you to think about that as well.
So if I can ask one other question. So then, we just have the ordinance that has a provision in there that we have the ability to go through the courts to get them to clean it up, just like we would a junkyard, say, right? And we have to make sure that within the ordinance we have some recourse in the courts, and of course, maybe we should make sure something's in the state statutes.
we could.
We probably need to do that too.
Depending on the size of the system will also determine when they get their incentives. So we're talking about they're going to get all their money and walk away. Well, when it comes to RECs, depending on the size of the system, for example, if it's a utility scale project, meaning it's bigger than 2 megawatts, that's over 15 years that they get those incentives. Also, the margins on solar panels, especially the smaller they get, are thinner. And so in order to really reap the full return on investment, they would have to keep them commissioned for at least the 20 to 25 years.
My other concern is these technologies change so quickly. If they could abandon a site, it's over technology. Right? I mean, they could have something running on a minimal level or whatever, but I guess my other concern would be, 20 years, their technology would be so obsolete in 20 years, I can't see them continuing to operate it, outside the collect tax credits or whatever credits they're getting. I mean, that's the other part of if they're not productive in contributing to, the power grid, so that'll be another concern of mine, is is these technologies will be totally obsolete. Probably within 10 years, I guess. They keep, you would know that better than I. Those technologies are changing pretty rapidly.
Steve?
Yeah, now I'm listening to this, and it comes to my mind that the landowner is going to make a profit off of leasing that stuff. And in essence, he's a private business owner, and we don't put fees or anything else, and we make the private business owner responsible for everything that happens on their property. So if the company goes in, stays there 3 years and leaves, that's the problem of the landowner, and the land use department or the county, whichever, is going to tell them to clean it up. And then the landowner should clean it up because they're the ones that made the profit to begin with. And then we don't have to worry about going out trying to come up with a fee to charge for doing this in a bond for 20 years. If we just make the landowner responsible, that ends it.
Judy?
So let's just say we do that, okay? So the landowner is gonna also abandon it, because they're not gonna be able to afford to take out all that stuff and put it back into farmland or whatever. They're not gonna be able to afford that. So now we have a piece of property.
No, but the landowner should charge that in the lease price. If they know up front they're gonna have to pay, then they're gonna have to get more money in their lease. And they can negotiate the lease and get the money. And that would make more sense to me, because now the county is not babysitting the whole project. The landowner's responsible. He's the one that's making the profit. So let him collect the money. If he can, he'll end up having to pay the fines.
Or he can
So-
purchase the bond.
I mean, but really, if the landowner includes in the lease the cost of, you can make a lease with declining costs, so that if it's gonna cost, I have no idea what it costs to get rid of it. But if it costs, let's say it costs $50,000 to get rid of it. Well, the landowner can say, all right, the first year you gotta pay $15,000, the second year, 10, the third year, keep going like that, or just start with the whole 50, you gotta pay it up front to the landowner, and the landowner has to clean it up.
I throw out, why is this any different than an industrial facility? Somebody wanted to come in and build a car plant, and it lasts for 10 years, and then they abandon it. We don't put a bond on those people to tear their factory down,
Right.
and turn it back to whatever it was before. Mike, you have
I was just going to add to the conversation that this is no different than a commercial building, a single-family residence. At some point, if that property becomes abandoned, if it's dilapidated, if it's an attractive nuisance, the county will do what's called clean and lien. We go through the courts, we obtain a court order, the property is demolished, and the property is liened for that cost.
But the property owner is always responsible.
The lien would affect the property owner.
Jim?
I was going to say that, the property owner is the one who has the recourse. Who wants to come up bankrupt, he takes it to the civil court. He would sue. I mean, for damages. He would sue for the cleanup. I think a lot of it does go to the property owner. The property owner can get some type of insurance, like a bond, if that's what he wanted to do. So I do think it should go back to the property owner. But they should be aware that they're responsible, and they negotiate their leases. And, I guess we could strongly recommend that there's certain things included in the lease, including decommissioning and abandonment. Since you said we review the leases, right?
We have all the best practices and disclosure leases from the Solar Energy Industries Association on our county website. And we also have the link to the American Bar Association, and our first advice under our education tab is to seek legal counsel first.
This is really because of the civil matter between the property owner and the developer of the solar.
Again, this is all brand new for us. In the meetings that I sat in on, my understanding was taking those things out was of monetary value, if there was because of the amount of recycling dollars that you get. Did I listen to you on that? Was I clear?
Yeah.
There's quite a bit of money involved in that. So for me, someone down the line will benefit from this. I mean, if you can recycle this and gain quite a bit of dollars in doing so, in decommissioning it, I don't see that any of this will happen, because that was what was indicated to me in the first meeting that I had, because that was the first question I had.
Okay, Kurt, where do we stand? Sounds like we don't want the bond.
Don't want the bond.
Okay.
But the ordinance will not expressly address the bond that the county holds. That's what I'm hearing that tone. Okay?
Okay.
Can I just say one? Here's the thing, so I was in IT for 30 years, and when I coded a program, I coded to say something could never happen is wrong. Anything that can happen will happen, it's just a matter of when. And if you coded a program with, well, that's probably never gonna happen, it's gonna blow up on you. Now, honest to God, I spent many nights with a person who was a younger programmer, I always got her on my team, and she always caused things that you thought would never happen to happen because of the way she coded. So I would just wanna make sure that we make it so that as a county, we've done the right thing. And if you said you looked at these different things, seen them, and had all that available, and you make the landowner aware of it, then Jim, then I think it's right what you're saying.
Well, I mean, solar panels, like building, they can come and go, but the land will always stay here, and that's what we're, be concerned about. It's the landowner's responsibility. I think we need to make that clear to people who are leaseholders, that they're responsible for what goes on in their property, not the county, not even the tenant. They are.
Right. We could always, since the lease, a redacted lease is required for submission for the special use permit, it could always be at the committee's discretion to see if there is nothing speaking to decommissioning to question the applicant on that portion of the submittal.
And I recommend it's a good practice to have something in.
Even if it's simply just to get for the scrap value of it, if it's not listed in there, then, then what do they know they're gonna decommission tomorrow? They come in tonight and they take it all out, and now the landowner has, I don't know. I just wanna make sure we've got all our bases covered.
So I just want to clarify that no construction bond is desired either.
Can I ask one other question about decommissioning? If they're to leave, what is the county going to require? Are we going to require them to remove all the underground cabling? Are we just telling them to take the surface stuff off? I'm actually also interested in what is the decommissioning? I mean, what would we require?
That's why we need to have a meeting on this and something set up.
We do have it listed in the ordinance, what would be required in the decommissioning plan, and we also do supply the developers who approach the county with interest in developing an example of a prime decommissioning plan that lists what actual equipment was put into the ground, what will be taken out, what the value of that equipment is, what that process and timeline looks like. That is something they have to submit to the county, as well as a specific decommissioning plan, and it also has to be signed by the subject property owner, so they know, they are aware that this is the obligation of the owner-operator of the system.
One of the problems I see with all that is if a company is bankrupt and they're just done, and they just walk away, it's gonna fall on the landowner anyway. So all this stuff that we're talking about, in my mind, has to go back to the landowner, so he has to make sure that he protects himself or herself by having enough money up front in the lease. Because how are you gonna get money out of a rock if the company's bankrupt?
And so what happens when the landowner says, I'm walking away too, then it falls on the county. The reason I'm asking about what's required, if we're gonna require them to take all the cabling out of the ground, maybe it's because we're gonna require them to go 2 feet into the ground. If we told them they had to go 4 feet, we could just leave it in place. It was decommissioned. So I'm interested in
removal of electrical components that are above the frost line, and then
Above the
of course,
frost
and the
line.
steel pylons and all of that
So do we require them to bury it below the frost line?
They would, yes.
We do.
Well, AT&T, any of those wires, they're all below the frost line.
What is that, about 30 now?
5 feet.
5 feet, 6 feet.
Not out in the country, AT&T caps their lines. If they're below the frost line, they're no longer needed, they cap them and leave them there.
So we do require them to bury their equipment below the frost line.
We don't require that, but we require that if it's above the frost line during decommissioning, they remove it. So above that 5 feet. I can't speak to what is
No.
required to the National Electric Code, how deep down the wires have to
Yeah, I think that's, to protect us, I would say they need to get below the frost line. That's the standard. What's Commonwealth, comment don't own the land. I guess they own the land, they don't generate electricity. So what's comment do if they go underground?
2 feet.
Mike,
The National Electric Code specifies burial depths for electric. It's dependent on raceway type, wiring type, and the property, where it's at on the property. Is it going under roadways? Is it going under structures? So that's all specified by current National Electric Code.
So what is it for?
It depends on the raceway type. So are you running in rigid? Is it Schedule 80 PVC, Schedule 40 PVC? Different raceways have different burial depths.
It's not like running power to like shed.
No.
These to generate power. I would think they would be.
So when you mentioned about AT&T, that they bury their line square below the frost line?
That's what I have been told, and Scott is still here, might be able to speak to how.
So so I work for a rural road district, we cut those lines all the time, it's mowing, because they're on top of the ground. So we want to make sure that they're going to follow what they have to follow, like it says.
okay, Kurt?
Thoughts on screening? Again, the draft currently expressly states that you're authorized to require visual screening when you feel that would be necessary to mitigate impacts on adjoining property owners. There has been a suggestion that screening should be objectively required in some cases. Do you have any thoughts about this? Would be like landscaping or some other.
Any comments by the board?
Denise left, but, she told me that, what about putting snow fencing up, and they were talking about the drain tiles cracking from the waking and all that stuff, and evergreen trees that evidently don't have deep roots, but, putting up a high fence that covers it all, but would the neighbors want to look at a big giant high fence? I doubt it.
Well, I think that the neighbors were very clear on what they needed. Yeah, and so snow fence is not.
I mean, I'm just saying, I'm repeating what she said, she left, okay? That don't mean I agree with it.
I'm just saying they were pretty clear about what they felt they needed.
So my thing is with fencing is, do you guys like your facility to be fenced in so no one can come in on it?
National Electric Code requires it.
Oh, so I mean, yeah, there you go.
I guess it's a matter of putting slats on the fence or not.
Right.
You're required to put up a fence.
Right.
Jim?
Yeah, can I also say our ordinance says adjoining property owners. When you start going beyond adjoining property owners, when you start talking about people who live a quarter of a mile down the road, even if they have a clear view to that site, I mean, I think you're opening up a really, going into an area that becomes really kind of shaky for me. I think it's a dangerous thing. People don't, they don't buy the air rights. They don't have a right to whatever view they feel they are entitled to. I would say that when we talk about adjoining property owners, not that you wouldn't listen to other folks, about, because they're adjoining neighbors. You know, so I would be careful about going down that road of people who live, you know, like I say, it's almost a quarter mile down the road. So, and I do agree with fencing. You know, if you get, like, put slats through fencing or however, and you can make it look attractive, to me, that could be better in landscaping. And so it's certainly less impact on the property. So, it's sort of just throw that out there.
So, here's the thing, landowners in the area are always gonna have something to say. If we can have a conversation with them beforehand, maybe come to a reasonable agreement, rather than then finding out about a project on Facebook. I think that.
Well, let me say this. Our ordinance requires adjoining property owners be notified.
Right.
From that point out, we publish, we stick stuff out on the property saying there's going to be hearing. So this idea that people aren't notified, I don't know how you want to notify. How far do you go out? They follow, anybody who's going in a zoning process, they follow the ordinance, which requires them to, for adjoining property owners. Beyond that, there's publications, there's postings, and I would say, you know, there's, you know, county board members. If you think it's going to be a broader based issue for the area, you know, try to get the word out there as best you can. I mean, you know, I take a little offense when people come here and say, well, I wasn't notified. So you live a quarter mile away. Why would you?
Right. When they had the public meeting, Lori and I were under the assumption that the neighborhood sort of knew, not just the adjoining property owners. So just one person showed up. We didn't know why that was. But so since we figured that one out.
Okay, I just want to say that they're applying with our ordinance.
Right.
You know, complying.
Any objection to us bringing back an ordinance that requires the drain tile surveys?
Oh, I think it's absolutely.
Okay. How about if they dig on the property, the separation of the topsoil from the subsoil? Okay. Again, you'll have another opportunity. You're not signing off on anything, but I just didn't want to bring back something that's anathema to how you feel at this point. So I think that's good on the solar farms. We have enough information, I think, to bring back a competent draft.
That's one of the questions. I haven't seen the ordinance. You know, like, while they were here, they mentioned they were going to put native plants underneath, which I think is great. Stabilizes the soil. It certainly helps with bees and butterflies and pollination and all that. But is that required in our ordinance? Because I would require that they put like they plant native plants under these structures. I thought that was a good idea.
Yeah,
That's actually.
it is required.
Yeah.
Is it required? And we
Already
can specify,
native ground cover.
we can specify native.
Well, it doesn't specify native, I'm sorry.
Can we do that?
It's all under the existing landscape portion of the zoning ordinance, which is heavily dedicated towards natural plantings, but it's not exclusively natural plantings.
I would like to say it should be native plants. I don't know.
You have perennial, but not native.
I would say native. They grow like crazy though. I don't know if it works this before.
So my question with that
But
is.
they can have little native plants.
Mark, does that limit us as to, would the only variety available require them to do more maintenance? Versus, I mean, they're not gonna mow underneath these things.
Theoretically, natives wouldn't require maintenance. They shouldn't.
Right.
I will say that I've been told on many occasions that the only thing that those horticulturists and landscape architects and arborists can agree on is that the only thing native really means is native to the United States, because this is a big point of contention within the industry. But I certainly take the sentiment that is going to require lower maintenance and is going to be viable. You do need to make sure that natives get established, but once established, they're sort of maintenance-free option.
I like them in my house, I don't touch them.
Well, we'll try and massage that language and apprise you of what we've done.
Are what you guys planning, is that considered a native?
Yeah, we propose native,
Okay.
native low growth.
Low
Okay.
grade, yeah.
Native low growth, there you go.
So you're pretty limited on the species, but I think native plants are great because it has other benefits besides the stabilizing soil.
Okay, ready for the fourth issue? Sure. Fourth issue is commercial vehicle parking. The draft that we've prepared as part of the overall package of amendments really is attempting to make an existing provision just a little clearer and understandable. And basically what it says is that in a residential setting, in a residential driveway, you're allowed to park one commercial vehicle. And the ordinance defines a commercial vehicle today. Existing ordinance says 8,000 pounds. That's a commercial vehicle. The initial draft, the one that's in the overall package, has a two-part test. Is it 8,000 pounds, and does it require or have a Class B void Illinois license tag? The idea that it's easier to sort of drive by and enforce if there's a complaint. You can look at the license tag and let the door jam the vehicle to figure out the weight. And then you can park an additional vehicle of that size elsewhere on the property, in a garage or somehow screened in a fenced-in area, some kind of enclosed structure. So our question for you all is, and it may not be entirely clear unless you're familiar with the license plate scheme that Illinois uses, but a Class B vehicle could be a F-450 pickup truck that could be quite customary. So it's not an incredibly large vehicle. The next classification up is a Class D tag. That goes up to 12,000 pounds.
Yes.
That is still going to catch some vehicles that are maybe just used by consumers and truly aren't commercial vehicles, but they are going to, they're going to be a more sizable vehicle. It's a really difficult issue. We've learned through some surveying that some municipalities even go higher than that. Municipalities. The new Lennox, I think, goes up to a Class F.
That's correct. F, yes.
F-size vehicle tag as the threshold for what constitutes a big commercial vehicle that isn't customarily parked in residential driveways and the like. So we've got a real kind of dilemma trying to figure out where that happy medium is. We can stay with the status quo, which is essentially what we have in the ordinance, or we can up those limits, or I think one of the things that was distributed as part of your packet is a kind of modified approach that New Lennox uses that's based on a combination of license tag and overall vehicle height, maybe a better proxy for what constitutes a very large vehicle that is not always appropriate in a residential setting. They do have that as part of their packet, is that right? All Lennox approach.
Ray, do you have
And I'm sorry I'm not sitting up there, I'm on a NACO call right now. So my question is, I think the committee needs to be very careful if we're going to try to push a B plate. There are a lot of smaller vehicles that have D plates, and I think B is almost too restrictive. That's my opinion. I know there are D plates, I have quite a few D plates that I have at work, and I bring the vehicles home, and they're not very large vehicles. I mean, they're like only 6,000 or 8,000 pound vehicles, and they're required to have a D plate. So by restricting us, I think that could be an issue.
I agree with Ray. I think we ought to increase the weight quite a bit. What's the weight for F? Maybe that's what we should.
16,000 is the upper limit, yeah, for the F.
I think we ought to increase it to F then. Because there are a lot of vehicles nowadays that are big. And then I just have one question on the, you're saying you can have two vehicles, one in a garage and one on a driveway. Well, how would, if you close your garage, which most people would do, how do you know you don't have a third? You go inspect garages at night, you know what I mean?
It's tough to enforce.
David?
So what I'm getting at is, maybe we gotta look at that, because we're not gonna talk about the building codes today, because we're definitely not gonna get time for it. But it's the same thing, if people are gonna do stuff that in violation of the law and think it's okay, because it's in a garage, we shouldn't have a rule that says you can't put your truck in the garage, you can't put two trucks in the garage. We should say you're allowed to have two, if you wanna put two, God bless you.
Well, this is
Close your garage.
This is a residential district.
Yeah, well, if it's in your garage, how do you see it? I mean, are you gonna go look around for two trucks in a garage, or wait for a guy to get up in the morning and go out and say which truck did he drive?
That's why we're buying the drones. I'm only kidding.
Mr. Moose, just be nice.
Can I ask, does this go uniformly across all residential zoning?
Yes, sir.
I think there lies the difficulty. Look, if you live in an R5 zoning district, maybe, one truck's too many, or two trucks is too many. If I got R1 zoning, and I have a lot of R1 zoning in the state zoning in my district, and the state zoning is residential zoning, you're going to apply the same standard if I live on an E1, 5.5 acre parcel that, and I have a, 150-foot driveway that you're never even going to see what I have back there, but yet we'll allow landscaping operations to operate out of E1. If there's a conflict, they have all types of commercial vehicles. I think that this really needs to be addressed by zoning classification. One shoe does not fit all here. I think that, and the problems that we've had have been in the more dense, like the R4, R5 type zones. So I do think that you have to look at the zoning classifications here.
David?
One option to address that possibly is to have the committee consider, like let's say, for example, R3 through R6, you can have one commercial vehicle. The others you can have up to two. Whether or not you want to keep them all D plate or B plate, that's something for the committee to discuss. Keep in mind is that the current ordinance requires it's only before these amendments is by pound by weight, which is 8,000, which is a B plate. As we discussed, even this morning, I took a picture of a truck that was driving by that had a D plate on it, and it was a Ford F-250 or something. It was something put into the back of the bed of the truck, and it was a contractor truck,
And it becomes a D plate.
with a D plate. So if we maintain the 8,000 pounds and continue with the D plate, you're going to categorically exclude those types of vehicles. Now, where you can kind of control that again is a height limitation of 90 inches, which is similar to what the Lennox has. But again, that's something we can look at with regard to the numbers of vehicles.
David, let me ask you this. E1, we allow, which really replaced A2, right? I mean, it's a kind of agricultural, residential. But under E1, my recollection is that we allow, under special use, landscaping operations.
Right, is that correct?
I don't think so, but I'm not sure.
Not according to my ordinance.
No. Well, my point is that you also need to look at what we allow under special use in those larger zoning. I mean, like the E1, E2. Because if we say on one hand, you can have this, and I can tell you we've granted it, whether it's in the ordinance or not, we've given it a number of years ago, my recollection, at least a couple of years ago. But we have let landscaping operations run out of E1. I mean, it was always a difficulty, where do you put landscaping operations?
Yeah.
You know, and I believe they're allowed in E1, even if it's by special use, they're allowed. So if you're gonna allow certain kinds of business activities under special use in these zoning classifications, then you can't say, and I'm using this as an example, you can't say you're allowed to have landscaping operation where you can't have any trucks there.
Right.
Right? You know, so I would review that, so there's not that conflict, is what I guess
Brian?
It may be possible at one time that landscaping was allowed. Currently, it's not. It's only permitted in the I districts as by right and with the special use in the A1. One area, though, that just popped into mind, if it was a state residential and it would matter, is if there was a horse trailer going to a horse stable, which is permitted uses in some of the estate districts.
That's a good point, if it was stable. Could they have a horse operation, right? Stable?
Stables are permitted uses in the E1 and E2 as an accessory use. I'd have to read the definition to see.
I think I have a lot of that in my district, that's why I'm asking.
So just right off the bat there, that would be problematic in the state districts. Even if it wasn't a commercial operation, those trucks have to be of a weight that would be above, I would think they would be.
I guess that's my point, is you have to review the classification.
Okay, Dave?
One thing that language we've been looking at with new Lennox, it distinguishes between commercial and non-commercial vehicles. And so what would be allowed is to have two non-commercial trailers with certain tagging on the property in addition to the commercial vehicles. So there is, we can look at that, but there is, it does distinguish between the two. But you do have to also keep in mind these all count towards the number of maximum vehicles that are allowed on the property as a whole. Just trying to keep a control on that. And Mr. Wardner, one of the things we did look at within the kind of revising the draft text was getting away whether or not something is inside of the building or outside of the building, in front of the fence, behind the fence. It'd be maximum two commercial vehicles on the lot.
Okay, as far as direction, let's say we'll raise the tonnage up to 16,000.
You want a D plate? D plate is 12.
16,000.
16.
16,000 goes to that plate. So that's like your 16-foot box truck. You know, like a cube truck.
Yeah.
So I think we need to look at what we allow, like Jim said, to make sure we don't allow it with the special use, but, I mean, we need to make sure that we are not more restricted to, you want to be restricted to a certain point, but it should be by zoning classification, I agree, because I don't want to become the village of New Lenox. I don't want to go by their codes, okay?
You know you want to.
I live in unincorporated Will County, and so does everyone else in ours, and we don't want to be New Lenox or Bolingbrook or Mokina. We don't want to be those villages that impose that stuff, so we need to look, like Jim said, at the zoning by the classification and then also the size of the vehicle and make sure we're not limiting on that.
And then allow it to plate on R1, but I wouldn't want to see it on R5 or R4.
Right.
R4.
Well, what about a guy that owns a plumbing company and he has a D plate or an F plate? And he drives that truck to and from work and he uses that truck for his
That's fine,
personal
but
stuff.
if he has 17 of them at his house, that's not good.
Oh, yeah, but if we're talking about not going that high,
Well,
He can.
he can park it on the street, but he can't put it on his property.
well, why couldn't you, if that's your car, why can't you put it in your driveway?
That would be crazy.
That's the way the law is.
Well, I mean, that's what we
The law
gotta,
should be changed.
we gotta say, well, why can't the guy that has a D plate that he uses for work, put it in his driveway, his own driveway?
We can't.
I mean, it's kind of ridiculous to me to say park it in the street, or go rent a place over in a parking lot somewhere.
We control the land, we don't control the street. He can park it on the street, but we
Well,
don't want these large vehicles on the property.
We'll come back to you with a little more sophisticated plan that takes into account the
Yeah, but why should we
district
change it to the
classification.
language? Let it park there.
And